In October 1985, a hostile raider laid siege to the cosmetics company Revlon. Michel C. Bergerac was Revlon's chief executive. Ronald Perelman was the chairman of Pantry Pride. He wanted to buy the company, but Bergerac adamantly opposed the offer. Perelman offered $45 a share. Revlon's investment banker was Lazard Frères. Lazard advised the board that this price was grossly inadequate. Lazard warned the board about a bust-up takeover. Perelman planned to use high-yield junk bond financing to buy the company. He would then sell off its assets to pay the debt. Revlon's special counsel was Martin Lipton. He recommended a note purchase rights plan. In the language of corporate takeovers, this is a poison pill. If anyone bought 20% of Revlon, other shareholders received a special right. They could exchange their common stock for $65 notes. These notes paid 12% interest. The board could redeem these rights early for 10 cents. Revlon launched its own exchange offer to buy back 10 million of its own shares. The company paid for these shares with new notes. These new notes contained strict covenants limiting Revlon's ability to incur new debt. The board successfully built a structural fortress. These defenses protected the corporate entity from a grossly inadequate price. They shielded the shareholders. The Delaware Supreme Court reviewed these early moves. The court applied the Unical standard. This standard governs a board facing a takeover threat. Directors must show they had reasonable grounds for believing a danger to corporate policy existed. The defensive measure must be reasonable in relation to the threat posed. The Delaware Supreme Court ruled the board acted properly at this stage. The poison pill and the exchange offer were valid exercises of business judgment. They spurred the bidding higher. They protected the shareholders. The initial tactics worked. They forced Pantry Pride to repeatedly raise its price. This chart tracks the escalating pressure. Pantry Pride offered $47.50. The bid climbed to $50. It reached $53, and then $56.25. The board authorized management to negotiate with a white knight. This was the leveraged buyout firm Forstmann Little. The breakup of the company became inevitable. It was clear to everyone that Revlon was for sale. This diagram shows the doctrinal shift triggered by the sale. The board's legal ditty shifted. The objective was no longer to protect or maintain the corporate enterprise. The whole question of defensive measures became moot. The directors had to stop defending the company. They had to start acting as auctioneers, charged with getting the highest price for the shareholders. Revlon agreed to waive the strict note covenants to facilitate a deal with Forstmann Little. The market value of the notes dropped from near par down to 87.5. Irate note holders threatened litigation against the directors. The board made a deal with Forstmann Little for $57.25 a share. The board gave the buyout firm a lockup option. This allowed Forstmann Little to buy the Vision Care and National Health Laboratories divisions for $525 million if another acquirer got 40% of Revlon shares. The price for those divisions was well below the value ascribed by Lazard Frères. The board also granted a no-shop provision, promising to deal exclusively with Forstmann Little. They added a $25 million cancellation fee. The board accepted this deal to support the sagging value of the notes. This maneuver was designed to protect the directors from personal liability to the angry creditors. The Court of Chancery enjoined the lockup, the no-shop, and the cancellation fee. The Delaware Supreme Court affirmed this decision. The directors claimed the Forstmann Little deal offered better financing. They pointed to note holder protection and a higher price. The court found the financing differences between the rival bidders were nominal. The Forstmann Little price margin was tiny when adjusted for the time value of money. The directors breached their fundamental duty of loyalty. They allowed considerations other than shareholder profit to affect their judgment. Lockups that draw bidders into an auction are legal. Lockups that end an active auction to the detriment of shareholders are strictly forbidden. The board argued they had an obligation to consider the note holders. This illustration maps the legal limit on outside interests. A board may consider other corporate constituencies, but this is allowed only if there is a rationally related benefit accruing to the stockholders. Concern for non-stockholder interests is inappropriate when an active auction is in progress. The note holders' rights were already fixed by contract. They required no further protection. This case is often cited as a broad command for shareholder primacy in all corporate life. The court actually ruled on a much more specific context. The decision legally defined a board's role during a sale. Market forces must be allowed to operate freely. They must bring the target's shareholders the best price available. Once dissolution became inevitable, the defenses had to drop. The auctioneer's gavel had to fall. Ultimately, those market forces favored the raider, and Perelman's side prevailed and acquired Revlon.